Hello, hello. We are live on the GDPR webinar. Welcome. I see we're still waiting for some participants, so I hope you are all right. Let's give them a few more minutes to join. And let's see if the chat is active. Everything is working fine. So, just a short introduction about the topic of today. We will speak about the General Data Protection Regulation, which is the new regulation of the European Union, which refers to the protection of the personal data of natural persons. So why is this important for you, no matter what country you're located in? Well, because if you're in business, you're most likely processing personal data. It might be the data of your clients, of your employees, of your business partners, and you should be aware of the legal requirements which go with it. The regulation is very tricky, from one side because it's quite vague in terms of the requirements, and the other because it's really strict in terms of the sanctions and the consequences. So what you might be risking in terms of the sanctions, it's actually the financial sanctions as well as the administrative sanctions from the side of the European regulators. So it is strict, but what is even more important is individual claims that you might be facing from the side of your individual clients. So while we're still waiting for some participants, let me introduce myself. I have been educated in various countries of the European Union. Um, I hold a MBA, which gives me the practical insights in business side. I am a member of the Bar of Advocates in Poland, which gives me the full qualifications to represent the business clients. Moreover, I have studied law in international universities in Poland as well as in Paris, France, and in Frankfurt am Main in Germany. I am fluent in English, Polish, and French. I also do speak German. I have worked for many years for international law firms. Currently, I am running my own practice and I am really focusing a lot on the general data protection regulation. As a part of international legal team, I have been advising companies from basically all over Europe as well as from North America. We did also have clients from other places, but Europe and North America have been my main focus. Okay, let's go through the requirements of the GDPR. What is it and why is it important? It is very likely that your organization is processing, assembling, analyzing the data. It might be called big data or just your client's data. You might be sourcing it through emails, through direct contact, through social media. You might also hold this information because you're performing a contract for your client. So it is very likely that you either hold it in your mailing system or your CRM system, which is the client's relationship management system. And you might also have some supporting software which goes with it, but also it might be an Excel sheet that you're using for your daily communication internally, as well as for the communication with the people on your list. So basically, as you can see, no matter what business you're in, you most likely do hold the personal data. The businesses that are most affected, it's the IT, it's marketing, it's e-commerce, services, sales, and basically any other business in which you have to communicate with your client, which is the individual person. When is it relevant for you? Well, basically now. You should be ready for the implementation and for the compliance by the 25th May 2018, because since then the regulation will be binding and it will affect the businesses not only in Europe but also outside of Europe. And I will explain you why in more detail in just a moment. What is really necessary for you to understand is that is the wave of new regulations that will have the global reach, and you will most likely be affected even if you are not located physically in the European Union. Why is that? It's most likely because if you're online, if you're doing online sales, if you're in e-commerce, you probably are managing personal data of individual clients also living in the European Union. So the regulation basically says that if you do process the personal data of people living in the European Union, you are bound by the requirements of this regulation. So you have to make sure that you approach data processing from the angle of security, of the priority of the regulation. If at any point in time it will turn up that you are not fulfilling those requirements, you might be facing the consequences of the individual claims as well as the administrative sanctions, which will be put upon you by the European regulators. So moving on, you will see that this will be a wave of new regulation. It will have the global reach, and many companies underestimate it. And unfortunately, those companies that will not get ready will be the first ones to suffer from the consequences of the regulation. Many people I know who are IT experts, IT security experts, are already ringing the alarm bell for their clients. They are trying to make all that is possible for them to prevent the client that this is going to happen. And the response for the market is basically twofold. There are companies that take compliance very seriously, extremely seriously, and they do not want to take the risks of exposing their companies to the claims. And there are companies that still prefer to remain ignorant, and unfortunately, those companies will be suffering. So if you ever participate in the discussions where you hear that this regulation is not relevant for your business, or that you do not have to comply, please do not listen to those voices, because this is simply incorrect. You will not be able to explain to any regulator or any court in the future that you have listened to some voices in the market and therefore you have not complied. Basically, compliance is your major duty. And so the first step for you is to identify if you really understand what the scope of the regulation is. So moving on, let's have a look at a little checklist. As you can see here, it is the little list of questions. Yeah, so let me show you the list in more detail so that you can see it clearly on your entire screen. So let's go through the questions line by line. So the first thing is, do you process the personal data? If you do have the data in your systems, ask yourself a question if it is the personal data. Basically, if you do not really know how to answer that question, maybe we should ask another hint for you, which is, do you know what personal data actually is? So how do you know if you are supposed to follow this regulation if you might not be fully clear on what the personal data actually is? Moving on, do you know the answer to the following question? Does your data processing include information about the residents of the European Union? So you might be processing the personal data, and now do you know how to answer this question? Do you know whether the emails that you have gathered in your email list are actually sourced from the residents of the European Union? Do you know how to identify them? And do you know if you actually have to comply with this regulation? Do you know what is client profiling, data pseudonymization, and data anonymization? If not, It will be very helpful if you just follow this presentation. I will give you some basic information on what it is, how to apply it in practice. Further, do you have any internal procedures and standards relating to the data protection? If the answer is no, then really you should focus on understanding what the data flow in your organization and whether you are able to generate the specific procedures and standards by yourself, or maybe you might need some help with that. Next, do you have any dedicated person responsible for the data security in your organization? Again, if the answer is no, maybe you should look into the regulation and know when are the cases when you absolutely have to have this kind of person on board, and what are the organizational requirements to get them prepared. Have you trained your staff on data protection procedures and requirements? This is a very important question. Do your people, do your employees, do your business partners know what it is important in terms of data protection and how to act and behave in terms of the security threats, in terms of the mishandling of the personal data of this information? They know what's the internal procedure, who they should notify if they are not sure if the system is working right, or maybe a document got lost with some important information. So if you do not have that done in your organization, it is definitely a point that you should have to look at. Next, do you outsource your services or use software as a service, such as autoresponders or mailing programs? If yes, you might want to look into that and see if they are safe in terms of the data security and if they are also compliant with the GDPR. Does your outsourced service have sufficient levels of protection of personal data, and where this information is actually physically stored? If you cannot find this information, it might be a good idea to reach out to the service providers to understand if they are prepared for the GDPR requirements. Is any of the services you use cloud-based? Why is this important? It's because the European Union considers certain locations more efficient and safer than others, which also refers to the physical placement of the servers that are used, the cloud computing software and systems. So if you are using cloud-based services, you might want to have a look at that as well. Do you know what is the exact physical location of the servers which are processing the data in the cloud computing systems, and are they located in the European Union? So, in short, if you are not sure about any of those questions that I just mentioned, you are very likely to be exposed to specific risks from the GDPR regulation, including the administrative sanctions and the individual claims. So now, basically, really now is the moment to get prepared. You only have a few months left, and you need to understand the regulations and train your people and take the specific measures to move on with that subject. You might be asking yourself a question: why is it even important for you if you are not located in the European Union or in Europe? Well, it doesn't really matter where you are physically located. What matters is that whether or not you are processing the personal data of the European Union citizens, so the residents. So you might be located in the US or in Canada, Australia, Japan, Indonesia, Brazil, wherever. Basically, it does not matter where your physical location is. What does matter is whether you hold the personal data of the residents of the European Union. So this is why it is a very revolutionary regulation. Before, the most of European laws, called the regulations and directives had the impact mainly in the European Union states. Not only, but it was the general and prevailing rule. And right now, we are looking at this regulation in much broader scope because it actually does not link to the physical location of the business. It links to the physical location of the people who are providing the personal data. So what is the main reason for this regulation? Well, basically what European Union says in the documents it has issued is that and nowadays, the individual people are providing more and more information about themselves. And unfortunately, this information has not always been handled properly, not always handled safely, not always respected. Also, not all the systems have been secure enough. So this means that they might have been exposed to the online security threats, but also they might be prone to the misuse by the users. Um, in consequence, such systems could be threatening to the security of this personal data and the specific person. It has happened in the past that people who gained information about the individual persons use this information to steal their identity, to commit the crimes of forgery. And you could see in the past that there have been huge data leaks. I will not be naming the names of the companies, but they were big international companies that didn't have any obligation on them to report that the personal data was breached in any way whatsoever. This might recall you a very, very a specific case of a international company which is providing email services which reported that the data breach happened a couple of years before. So under the new regulation, it will not be possible to withhold this kind of reporting for so long. You will see that the new regulation is actually quite strict and it requires you to report the data breach as soon as possible, and it actually gives a specific timeline. So, like moving on to the more legal issues, and just to give you the general background of what the general data protection regulation actually is legally, I will just give you a very broad information how the European law actually is. A regulation is a legal act issued by the European Union which has uh, the, the feature of direct applicability. What is very important to understand about the regulation is that as opposed to the directive, an individual person can uh, go directly to a regulation, point out on a specific article, specific provision, and say, this document gives me the right to XYZ. In terms of GDPR, it will be the protection of the personal data, as well as the possibility to claim the compensation. So to actually bring a lawsuit in case the personal data is not protected sufficiently, if there has been a breach of the GDPR and the breach of the personal data. So GDPR is very powerful, as you can see. It actually provides the individual people with the possibility to claim their rights, claim the protection of their rights directly from this specific document without having to wait for any local regulation for any local countries to get specific regulations, local regulations. So an individual person does not have to wait for individual local laws in their own countries. They can go directly to the GDPR, open this regulation, point out that their rights have been breached, and as a consequence, they might be claiming a reparation of damages. So that is why it is so powerful. It's not only because of the administrative, so the governmental control, it is also because the individual people have the possibility to claim their own rights directly. So I hope you understand now why this document is so revolutionary in its own nature and why it is so important to follow the rules of GDPR right now, so that you get prepared by the implementation date of the 25th May 2018. We are expecting it's going to have a huge and immediate impact as of day one of this regulation. Honestly, I have already seen the attempt of some lawyers to establish the practices which will be supporting the claims directly um, mm, from day one. So from the 25th May 2018, they will be working with the individual people who may want to bring their claims against the businesses that are mishandling the personal data. So let's move on to some principles that will be important for you to understand this regulation. One of the main rules introduced by the GDPR is the accountability and privacy by design, privacy by default. As you can see on the slide, the GDPR applies severe sanctions and obligations on data controllers to prove compliance. Those obligations include maintaining certain documentation, conducting a data protection impact assessment for more risky processing, implement data protection by design and by default, implement organizational and technical solutions which will enable to measure the level of data security. Pursuant to the GDPR, the entities which collect personal data will have to notify cases of data security breaches to the respective national regulator for data protection. Such regulator must be notified without undue delay, and that notification should happen within 72 hours following such breach. And in some cases, not all cases, but in certain severe cases, this notification should also go to the individuals whose rights have been breached and whose data might be now prone to specific risks of mishandling and misuse. So, what is the geographical impact of the GDPR? Well, it's not only Europe, it's basically the entire world. The sanctions will apply also if you do not have your registered office in the European Union. So who is affected by the GDPR? It's companies which process the personal data, so the data of the individual clients. That means the companies that are the data administrators and data processors. So if you are the entity that is deciding on the goal of the data processing, your liability is not limited. You are the entity that is primarily responsible for keeping the data safe and for respecting all the duties that go with the GDPR, which result from the specific procedures and specific standards that you have to respect and you have to have in your company. It's a very serious topic. If you do have personal data, you have to have the procedures on the proper handling of it. Otherwise, you will be easily exposed to the claims saying that you haven't kept the due diligence for keeping the data safe. You haven't even had any procedures in place, which in cases of individual claims will be a very, very difficult situation for you to prove that you have done everything you could to protect the data. If you do not have the basics in place, you will not be able to fight against any individual claims. And imagine that out of, let's say, 1,000 customers that you have, at least 10 of them would have such claims and will bring their claims to court. And then instead of handling your business, you would have to handle such claims. And this is a very, very small number. Imagine that you have many more clients and this number grows. Let's move on. So in which fields of business are you most affected? I mentioned it before, but just to remind you, I know there's lots of information here, so I would like you to understand it as best as you can. The sectors are affected by the GDPR are limitless, basically, but those that have the most risks are the IT companies on one hand, because they might be handling the data for other companies and provide the technical support and the hardware for processing such data, but also because they might be developing specific solutions such as software, such as the online applications that include a number of personal data which might be prone to the security threats, to hacking, to the attempt of um, breaking into the servers, either in terms of using the internet connection or physically threatening the security of the hardware that you are storing in your facilities. So for IT companies, the GDPR compliance is an absolute must-have. You really have to have that in place. You really have to make sure that it is working properly for you. In terms of other companies, basically, if you do hold a database, it might be an Excel sheet, it might be a CRM system, it might be a Know Your Customer system, which brings together some information about your customers. You might be using profiling, which is subject to new restrictions under the GDPR. So you not always are able and allowed to profile your clients. And I will explain that a little later so that you're more clear about it. Moreover, if you hold an online business, e-commerce, if you have an online store, you are most likely collecting the personal data, even for the sake of delivering the goods that your clients are ordering from you. So if you do hold the information about their first name, last name, the payment details, banking details, and their address of delivery, that might be their home address, their business address, doesn't matter if it's the information which allows you to identify an individual person, it is classified as the personal data and it has to be protected. So if you do have an online business, so e-commerce, e-store, IT company, if you are approaching your clients with the information about your new services, if you're proposing new purchases to them through email marketing. So you're using actively call centers, email marketing, you're connecting with them. You must make sure that the data that you're using for this communication is stored securely and that you are allowed to send them those emails, because the GDPR is not only about the storing and the processing the data in terms of having it technically safe. It is also very strongly showing the necessity of getting all the client consent or another legal base in them. So if you have reached out to them to provide a specific service with a specific goal in mind, and then you are using this information just for the marketing of your affiliate programs or using it to upsell your other products, it not always might be considered as compliant with the GDPR. So make sure you have this sorted out as well. Obviously, all other sectors, especially the regulated sectors, such as banks, insurance companies, and all the companies that work with them, are also affected by the GDPR. So it is very important that you understand this regulation. In the short time that we have, it is virtually impossible to tell you all the details about this regulation. So this is why I'm focusing on the specific points that are important for you to understand. And probably one of the main questions you're asking yourself is, okay, I now understand that this regulation is important, that it is necessary to make sure that I am compliant as a business person. However, what happens if I do not comply? What happens if there is something that I do that is not fully compliant with GDPR and I didn't even know about it? What do I risk? So as I said before, there are three types of sanctions that you may expect. One is the administrative sanction, and it has two types. It might be a obligation or a prohibition that the regulator would put upon you. In some cases, it might even consist of the prohibition of processing the personal data, which for an average business, especially online business, means actually the necessity to stop all the operations. So it might mean the end of the business. That is why it's so important to understand it. It is so important that you guys get prepared and you get it sorted out. So apart from those operational sanctions, you might also be facing the sanction of a financial fine. And those are the very, very high numbers, unusually high in the European regulations. And it's mainly because there are lots of corporations which do handle personal data, and without severe financial sanctions, they wouldn't feel that this is the thing to make a priority here and now. So the sanctions for some infringements, some breaches would be as high as 10 million euro or 2% of the annual worldwide turnover, and the binding number will be the higher one. So if the turnover is really high, then it will be the 2% that applies rather than the 10 million. And in very severe cases, the fines might go even up to the 20 million euro or the 4% of the annual worldwide turnover. As before, the higher number will be the decisive one. So as you can see, the sanctions are really, really high. They're very important in terms of the relation to the business that you're running, and if the regulation is not respected, if your company is not compliant, you might really have hard times. The second type of sanctions, it's the individual claims, which I mentioned before, which means that an individual person who knows that their personal information has been breached by your company may bring a legal claim against you, may trigger a legal action in court against your company. And this is a massive, massive issue because if you have a look at the number of the clients and the number of the records of the personal data that you have in your systems, you will see how huge this sanction, this consequence might be for your business. In terms of the legal fees that you will be facing, in terms of all the stress, and in terms of hiring a person who would have to handle those issues. It is really, really important that you understand this, and my mission is to actually help you understand it and help you prepare for this, to explain to you why you should take care of this right now. That is why I'm doing this training to get this information out there, to get this awareness out there. So those are the two types of sanctions, so the administrative sanction and then the individual claims. And the third type of sanctions might be the criminal sanctions. Those sanctions will be applied based on the local regulation of a specific member state. And here the regulation, it gives a bit more flexibility to the member states in terms of choosing those kinds of sanctions, choosing the procedures. However, I know that in some European Union countries, those criminal sanctions are already in the new laws or in the draft laws that are waiting to be finalized by the parliament. So it is really severe. The administrative sanctions, individuals, and the criminal sanctions, it is a regulation to consider very seriously. Okay, so let's move on. Well, the client will have the right to engage into the court action, litigation, and sue the company for indemnification and or damages. So this means an actual financial risk for your company for the incompliance. So make sure you have this sorted out. The GDPR creates duties as well as business opportunities for professionals in data processing and data industries. So you should not really look at this regulation as a burden, as a threat. It actually is also an opportunity. If your company is processing the personal data safely, you can show this as a huge asset to your clients, to the market, saying that you are safe, that the client's data is safe with you, and like this, you are providing the services which are more reliable than those of your competitors. So it is a good thing to get interested in this regulation because this might be an actual competitive advantage for your companies. Also, you should know that certain duties under the GDPR may be outsourced to specialized entities and supported by professional consultants. So you don't have to do it all by yourself. Some of the issues will have to be sorted by you and your employees, but some tasks might be outsourced to other companies. So make the market research to find the companies that you can rely on. The GDPR will apply globally. Any companies in the world that are processing the personal data of the EU residents will have to comply. These regulations are particularly important for outsourcing companies. So again, I cannot say it enough. Make sure that if you're in IT, accounting, call centers, marketing centers, you have lots of personal data, you should get prepared. Also, if you have the sensitive data, so if you're medical business, maybe in some qualified fitness services where you have information about your client's health, and they progress the information that could somehow affect their medical state, especially if either released to the outside world or if it's hacked in your system. After some time, it turns out it's incorrect. It is very serious if this information is for any reason made incorrect by the outside ingerence. This will actually cause the threats to the health and maybe even life of your clients. So you have to make sure that this information is correct and it's secure. So I hope this is clear for you. It is very important that you keep those measures in place. So what are the other issues that you should be aware of? Well, basically, you should know and you should understand what personal data actually is. How to protect the personal data? What's the application of the personal data to any machine processing, machine learning, meaning processing this information in some advanced algorithms that you might be using in your business. So I will move on to that. This is more practical, but at the same time, the more strictly legal part of the GDPR. So let's get going. What is personal data according to the GDPR? It is information relating to an identified or identifiable natural person who is called a data subject. In other words, it's any information stored electronically or in documentary form which enables to identify a specific individual person. What are the examples of personal data? Well, the GDPR does not give you the exhaustive list of the elements that might fall under the definition of the personal data, but it gives you the specific guidelines. And based on those guidelines, you might probably intuitively know that the personal data would be information such as the name, address, date, and then place of birth, the gender, marital information. So, are you married or not? What's your spouse's name, etc. What are your kids' names? Then any numbers of documents such as ID or passport number or a driving license number, tax ID. Those are the elements that might easily serve to identifying you as a individual person, your client, business partner, your employee. Further, a bank account number, history of bank transactions, and credit history. So if it's a printout from your banking system, there is most likely an information about the bank account holder and the number of the bank account, and with the use of some additional information, it might serve to identifying a specific individual person. And then employment conditions, salary, it is also information that may be classified as the personal data. So those were the intuitive examples, but let's move on to the examples which might be actually surprising for you. So have you ever had a shopping cart, a discount card that would be given out to you so that you can have a better offer in the store that you make your shopping? Well, in such cases, you most likely have to give out some specific personal information about your name, your address, your phone number, your email address. And with this information, the store, each time you're doing the shopping, you're asking for some additional points on your card, the store will gather the information about your shopping preferences, and like this it will know what is your shopping profile, whether what are the times you're doing the shopping, what are the locations, what are the products you're buying. So based on this information, they're able to uh, understand who their clients are, but at the same time, they know a lot more about you than you would ever expect. So if you are running a business that actually uses those solutions, you are processing the personal data, and you most likely are applying the profiling of clients, which is subject to the GDPR. So what are the other types of information that might be classified as personal data? Is the IP numbers, so any numbers of the computers, IPs, and also the mobile devices, tablets, mobile phones. Those devices have their individual numbers, and through those numbers, it is possible to identify a specific individual person. And this is why those numbers are also classified by European Union in the category of the personal data. It might also refer to the SIM numbers of the SIM cards for the mobile phones. They're unique numbers assigned to a specific user, and this is why storing this information means that you are storing the personal data. Any other information about the ownership of assets like real estate, movables, IP shareholdings, such documents that sum up your assets, inform the third parties that you are the owner, or your client is the owner of such information, actually also means that you hold and you might be processing the personal data. Further, such information such as DNA, medical information, biometric, it's not only the personal data, it's the sensitive data. So it actually falls into the category of information which is subject to even more rules and restrictions. And the breach of such information, the breach into the systems where such information is stored, is treated very severely, and that is why if you do hold such information, you should make sure it is stored safely. Also, such information such as court sentences, even criminal, civil, administrative, such documents also do include administrative data. So if you are collecting the documents that include such information, you should make sure it's stored securely. As you can see on the next slide, the data security is the key aspect of the GDPR. Businesses are currently facing a rising demand for data security experts and services. Personal data is particularly sensitive for the reasons of individual security and privacy. The GDPR aims to ensure the security of personal data and to prevent its unauthorized use. In brief, it allows the individuals to control who is processing their data and for what purposes. The entity collecting personal data must be able to prove that the individual person granted their consent for data processing. This requirement is particularly strict for the sensitive data. And the GDPR includes the individual's right to be forgotten. That is, to have her or his information deleted from the databases. So there's a number of aspects that go with the GDPR and the rights of the individuals that stem from the GDPR regulation. Why is this sensitive for businesses? Well, it's because information is money. Information nowadays is the most valuable asset. It allows businesses to reach their customers effectively. So it means the marketing, the sales, the maintaining of ongoing relationship with the client. So if you do have the clients about the and you know more about them than just their last purchase in your store, you probably are trying to collect this information and make the tailor-made offers to them. At least this is very common practice, especially in e-commerce, online businesses, gathering the information about the individuals and then sending them updates, newsletters, and the offers for the next purchases. Probably any individual person has seen lots of emails sent out by uh, the businesses that they have transacted with before. So the information relating to individuals allows businesses to understand the client's behaviors, preferences. This is why many companies decide to have the shopping carts with discounts. The discount is not only a gift to the client, it actually is an incentive um, which helps a business to get more specific information about the client. So it also informs the business about the spending habits and possibilities, the potential profitability of new products, services, and then it's used for optimizing the marketing campaigns all over the world. So in the consequence, the information is actually the key resource for increasing the profitability of the business. So you probably have noticed that nowadays uh, the market is customer centric. Many services are customized so that the clients can get the service or the product that they want, that they like, that they don't really want to choose a standard product. And this is why the businesses that have the more and more information about their clients are increasing their efficiency and profitability through having as much information about their clients as possible and putting this information in different categories, repackaging it and analyzing either by the marketing specialist uh, in the company or through the specific algorithm that the companies are using very often in the software that they purchase from the market. So this brings me further to the machine learning. Many businesses are using the software and the algorithms to improve their day-to-day efficiency. The modern software is accumulating the countless data about the customers and the businesses. The machine learning enables to create analytical tools and marketing strategies based on algorithms applied to the stored data. So that's in short the machine learning. From the very practical and very simplified point of view in the context of the GDPR. Obviously, there's lots of other science behind it, but let's just keep it simple for the sake of understanding the GDPR. Machine learning has a lot to do with the client profiling. Customized services and products based on the accumulated data are becoming a growing trend in leveraging businesses and their marketing expenses. Such solutions are already applied by certain innovative retail chains, banks, etc., to track the specific customers and build a database relevant to them and their behaviors. The process is called the client profiling. Banks are using client profiling for checking their credit history, spending habits, comparing information available in social media with the submitted documents and credit applications. So you might not even know, but the information that you put in the social media is sourced by the bots, the robots, and the algorithms that are used by other companies, and those algorithms might be comparing whether the information that you provide in your credit application is accurate. If you are telling to the bank that you need more funding and that you have a very modest life and that you basically will be able to repay the next tranches of the financing, while all your social media is showing that you're spending lots of money on expensive gadgets, you might not even know that this will be the reason for rejecting the application. So this is the perspective of the individual clients versus banks. But if you are a business person and you are using some such techniques, some algorithm, you might be very tempted to collect the information available publicly and in social media for approaching your own clients. And you should know that for such practices, you will be need to inform the person that they will uh, be subject to the profiling and they may protest against it, or you will have to accept that this profiling will not be possible because they do not give you the consent at all for such a practice. So if you are not able to prove that you have the consent for profiling, or that the client proves that they have denied the possibility of profiling, you are not able to analyze this data in such way. That is why it's very important that you understand in detail how this process works. We don't really have that much time to go deeply in those specific regulations. I just want to give you the general overview and inform you about the main issues and the main risks that you will be facing. And obviously, for the detailed advice, it is best to ask the individual questions to the legal counsel so that you understand how to process with your business. Client profiling means accumulating data about specific customers or groups of customers, classifying them based on specific features, and making business decisions related to the individual customers based on this process. Okay? Specific examples include analyzing or predicting aspects concerning that a natural person's performance at work, economic situation, health, personal preferences, interest, reliability, behavior, location, or movement. It is not allowed to make the decisions regarding data subjects uniquely based on the algorithm and uniquely based on the profiling without when a person looking at the specific application and making the final decision. So this applies to the automated data processing. The algorithm may not make a decision without having a person, an expert, looking at this information. This in particular refers to the bank loans, the credits. A bank may not deny a loan to an individual person just based on the algorithm. There must be a banker looking at this information, a financial analyst, a person, in addition to the algorithm. So what are the profiling measures? For all permissible profiling, GDPR requires the controller to use the appropriate mathematical or statistical procedures, implement technical and organizational measures to correct personal data and inaccuracies that allow to avoid errors. Further, it requires to secure all personal data and minimize the risk of discriminatory effects against natural persons on the basis of racial or ethnic origin, political opinion, religious beliefs, trade union membership, genetic or health status, or sexual orientation. What is important is it happened in the past that some institutions did make the decisions based on those criteria, which were discriminatory as the end effect, and such practice is considered illegal under the GDPR. So you cannot do it as a business, as an institution, it is important to treat the clients equally without having different offers to the people of different individual features, which I just mentioned. So the person whose personal data is processed has the right to be informed about the profiling. It's the disclosure of the existence of the automated decision making, including profiling, along with the significance and the envisaged consequences of such processing for the data subject. Also, the person has the right to object to the processing for direct marketing as well as to profiling to the extent that it's related to direct marketing. So all marketers out there, this information is crucial for your everyday life, your everyday work. The individual claims might be based also on the bad application of GDPR to the marketing. You have to have the consent for sending out the marketing information. And also, if you want to profile your clients in your CRM systems and know what kind of information you should be sending to whom, you should have a legal basis for that. And if a person who is subject to profiling objects to being profiled for the marketing processes, you cannot process this data any longer for your marketing based on the profiling practice. Okay? The clients should be provided with the profiling notice and the access to their personal information. As you can see, there is a lot of additional details to that. If you would like to have more detailed information from my side, I'll be happy to provide it in a separate webinar, separate training. It is just too much of very specific information to go through that through one webinar, which is focusing on the basic outline of the new rules. The restrictions to the profiling based decisions are outlined also in Article 22. The decision may be made if it is necessary for entering into or performance of a contract between the data subject and a data controller, when it is authorized by the European Union or a member state law to which the controller is subject, and which also lays down suitable measures of safeguard the data subject's right and freedom and legitimate interest, or based on the data subject's explicit consent. So the data subject is the individual person that we're talking about. So in short, if you are entering in a contract with an individual person, or if there is a separate law that says that you can apply profiling to the decision-making process, or your client actually tells you it's okay, that you do have the consent from the client, those are the situations when you can process the data with that algorithm, with the profiling, and make decisions based on that. So what's the conclusion? If you would like to still be profiling your clients, and based on that you want to issue the decisions, you should have that written in your contracts, or you have to get your client's consent. Alternatively, you should look for another legal basis in the European law or in the local law. So most practical tip is to actually get the client's consent either through contract or a separate form. Let's go quickly through some basic definitions of the GDPR, and that can help you protect your business and put in place certain processes that will show your due diligence in your compliance. So European Union says that if you as a company are using the pseudonymization of data, you are applying some safety measures under the GDPR. What is the pseudonymization? Well, in short, is the processing of personal data in such a way that the data can no longer be attributed to a specific data subject without the use of the additional information. So if you have information about, let's say, John Smith in your IT system, and you would like to make sure that in case there is any security threat, any security breach into your IT system, this data does not cause any harm to Mr. Smith or to your company as a consequence of the data breach. You can store this information in separate places, separate servers, separate systems, separate softwares, and basically encrypt the data. So in one of your systems, you would keep the information about the first name and the last name of Mr. John Smith. In another place, you will keep the ID that is assigned to Mr. Smith, or that means a sequence of numbers, of letters, something which is random and does not point out specifically to the name of John Smith. And in a separate system or place, you store the key to this encryption. So without the key, you cannot really connect this information to one another. This is what pseudonymization of data is. So in short, you encrypt the data by using um, an additional ID, an additional system in which you operate with the, let's say, the purchase preference of a specific client or the history of orders of the specific clients, just based on their ID, which does not show any other information that could help identify them. So no address, no details that could bring you to Mr. John Smith. So without this security key, you are not able to identify this individual person. And as this information requires some additional steps to either reveal this data to the public or to the third unauthorized party, this method is considered as far safer than just keeping all this information together, let's say in an Excel file on your computer or in a CRM system which has all this information in one chart. Still, this information is considered as personal data, so even though a random person would not be able to identify Mr. John Smith or whoever other person, still by the use of the encryption key, it would be possible to track back on this individual person. So this process is reversible, and as a consequence, you are processing the personal data. Okay, so this is limiting your exposure to the legal risks, the legal claims and sanctions. However, it does not carve out all the obligations that you are subject to as a business that is processing the personal data. Which brings us to another notion, which is called data anonymization. The data which is anonymous is saved in such a way that you cannot track in any method whatsoever who this data refers to. So if in your system you are holding some information let's say it's for statistical purposes, that only shows solely numbers and does not include any ID numbers, any IP numbers, any documents, any photographs, nothing that could allow you to identify a specific person. In such a case, you are storing the anonymous data, which by definition is not the personal data. So as a consequence, in those cases, you are not subject to the GDPR regulations in this specific aspect. Okay, so we have gone through the most um, important information that I could give you within such a short time frame. I hope you have enjoyed it. There's obviously a lot of other information, other rules that you will have to be aware of. And if you need any other additional help with those issues, I will be happy to help you out. These are my contact details. You have probably seen the website on the slide before, but this is the summary. This is how you can contact me. Again, this is my short bio. I hope you see that this experience of working a lot with international businesses gives me this practical approach, and I'm trying to give you the real life examples of how you should actually understand your obligations and what you should be expecting on the GDPR. And I am more than happy to say even more during the individual conversation or on a separate webinar. This is how you can prepare for the GDPR. Some steps which are recommended by the practitioners who are already preparing companies, and I also support this system of step-by-step procedure of how to get prepared for the GDPR. First of all, take action, become aware. Second of all, train your staff. They have to know what GDPR is about and how to apply the security measures. You are not able to run this business on your own. If you're working with a team, every person on the team has to be aware of the risks and of all the issues that appear under the GDPR. Third step, do a general data protection assessment of your firm. You have to know what is going on in your company, whether you are subject to the GDPR or not, and do you have any procedures in place, and so on. Fourth, identify what still needs to be done to comply with the GDPR. So that's so-called the gap analysis. You have to know what you have to do in order to comply and how far you are from attaining that goal. 5, create a detailed compliance plan. Indicate tasks and timelines for making your firm compliant with the GDPR. And 6, decide if you need to appoint a data protection officer. So this is a separate subject. A data protection officer is not required for every company. The GDPR obviously recommends that every company has a person in charge, but the official function of the data protection officer is introduced for certain types of businesses. Okay, so I will be happy to help you out. As you can see, I am providing consultancy in other languages, mostly in English, but I'm native Polish. I graduated from studies in France, and I did study in Germany, so I'm happy to help you by applying my knowledge in those languages and by doing research in those areas. And remember, this presentation is very general. It is a very general outline of the requirements of the GDPR, it is not sufficient for your business to move on without the specific tailored made advice. So what I can do within this very short time is to give you more awareness, help you with the education in that subject matter, but for making your company actually compliant with the GDPR, you will really need to get the separate dedicated advice. And if you would like to get in touch with me, I'm more than happy to help you out. But please just um, remember that this presentation has been made available for you for the educational purposes, and any compliance issues must be subject to separate agreement and uh, separate terms of cooperation on the legal advice. So this is a general legal statement I just have to give you so that you know that this is not the full information that you have to have. There's so much more that you need to learn, and more information that you have to understand. But I hope that this at least gave you the general overview, especially if you are not a European company, if you are not a European business. I am hoping that this has helped you to understand way better the requirements which are ahead of you. So, having said that, I hope you enjoyed this webinar, and I am really looking forward to many more to come, and I am hoping to have many of you back in the next webinars that I will be organizing, as well as the dedicated courses on the GDPR. So if you do have any specific questions, if you're dealing with any particular issues that you still do not understand, something that was presented maybe too fast, or you have seen some confusing information somewhere online or in your conversations with anyone, just feel free to let me know. I will be happy to prepare a separate training on that, so that you can feel way more comfortable with this subject, and that you can start preparing the compliance for your company. You really, guys, have to get going with the compliance. There's little time, so go ahead and take action.